All right, everybody, just about one more minute. We're gonna get ready to rock and roll on NABOR's forums. Let a few more people join. Go ahead and mute yourself when you, if you can, so that we can get through this. All right, it's 10 o'clock. Let's get started. Good morning. Today is August 12th, and that's important because as we approach the deadline of August 17th, we can expect new and more information to be coming out on today's topic. So I'll keep everybody up to date. To start off, of course, my name is Sam Saad. I am an attorney here in Naples, practicing throughout the state of Florida. And today we are going to talk about the National Association of Realtors Global Settlement and the NABOR forums. That's the Naples Area Board of Realtors forums. Now, to begin with, immediately, I want everyone to hear, and I'm going to repeat this if it happens again, is no numbers, no fruit, no bananas. If you have a question about compensation, just say X. X amount, Y less than X, that sort of thing. Let's not have any antitrust violations on this particular call. Now, I am an attorney, so we're going to start off with a disclaimer. I am giving you advice, but it's not legal advice necessarily, and no attorney-client relationship is being formed. A little bit about me. I can tell I know most of you on here, which is great, but I've been doing this for about 20 years, and I serve on the NABOR Legal Resources Committee and the FAR-BAR Joint FAR-BAR Contract Committee. So I know these forms that y'all are using in your business, work on the forms, help draft the forms. And if you are looking for closing services, of course, my law firm or my title company, Paradise Coast Title and Escrow, can help you get through your closings. We close throughout the state of Florida, and our goal is to keep you, the realtor, and your customers informed and provide exceptional service. So if you have any questions in that regard, contact me afterwards. So today, we're going to review the NAR settlement. We're going to look at the practice changes under the settlement. Then we're going to review the revised and new NABOR forms. And we're going to go through some tips and tricks to survive the settlement as you advance in your business. And again, when you join, go ahead and mute yourself. And that way we won't have to stop for disturbances. All right, so let's dive right into the NAR settlement. First, I want you to take a look at the timeline. So the judgment against NAR and the Realtors was October 31st of 2023, Halloween, and it was for a little over $5 billion if you account for treble damages. And the settlement was assigned March 15th of this year. The most important date, of course, is the August 17th date when the practice changes take effect, and that's what we're really going to be talking about today. But I do want to warn everybody that the Department of Justice needs to weigh in on this settlement, and the court is having its final approval hearing on November 26th. So just be advised and be warned that everything I say today could change or be adjusted as we go through the settlement process. You will want to keep up on the emails and the email blasts from NAR, from me, from NABOR, as we try to get through this whole process together. But a little bit about the settlement. If you're an NAR member as of the class notice date, then you're covered unless you're one of the big brokerages that settled separately, or you're with Home Services of America companies, Berkshire Hathaway, then they have their own settlements. The class notice we said will go out August 17th, and everybody under $2 billion is pretty much covered. Now, the most important paragraph, and what we're going to be really talking about today, is paragraph 58 of the settlement agreement. I don't know how many people have seen this, but I want to show it to you on the screen. You can see this is paragraph 58 of the settlement agreement, and that's what we're going to talk about here for a minute. Oh, by the way, if you have questions, feel free to unmute yourself, shout them out, or type it into the chat. I'm monitoring both as we go through this, and I will answer questions. I may pause on your question for a minute while I finish my thought, but then I'll come back to the questions as we go through this. So talking about paragraph 58 of the settlement agreement, again, they undergo effective August 17th. As you probably already know, Southwest Florida MLS removed the compensation fields as of August 1st. Concessions are going to be allowed board by board, but this could change. Right now, the boards are allowing you to say in your confidential remarks that concessions are offered, concessions are not offered, or concessions are negotiable. They really don't want to see anything else other than one of those three phrases in the confidential remarks as regard to concessions. And of course, nothing, not one sentence or word about compensation. And I see a lot of things on Facebook and on Instagram about trying to manipulate the system. Just as we talk about this, it's not that tough to advertise your compensation. You just can't do it through MLS. So there's plenty of other opportunities to advertise your compensation, and it really is just MLS that is restricted. So we'll talk about that. The other sections of paragraph 58 relate to settlement of the settlement agreement, relate to settlement payments and definitions. That's the bulk of the almost 200-page settlement agreement. And the brokerages and boards have paperwork to do to opt into the class. So what's changing in MLS? Number one, they are eliminating and prohibiting any requirement that listing brokers or sellers make offers of compensation to buyers or buyers brokers through the MLS. They're eliminating and prohibiting the requirements that offers of compensation be blanket, unconditional, or unilateral, which means that you can now make conditional offers of compensation. And they are prohibiting offers of compensation anywhere on the MLS, including removing all fields. And they're not allowing any mechanism to facilitate offers of compensation through the MLS. And this pretty much includes the showing time and things like that. However, this is a big however, brokers may share compensation on their advertising in their websites. They simply must be more than one click away from the MLS. We're calling that the 2-click rule. So if you go from MLS to, say, your homepage, and then from your homepage to another page that lists your broker compensation for all of your listings, that would be perfectly acceptable under the settlement terms. You could I've heard people say they're going to do like a Google Drive document, a PDF that you can click to from your website and have your compensation information there. That's totally okay under the settlement. It can be on a web, like a landing page for the property itself. If you one of those realtors who likes to make a separate website for each listing, perfectly allowed. Simply needs to be 2 clicks off the MLS. And of course, it's a weird way to say it because MLS doesn't allow links in the confidential remarks. But so you basically copy and paste the URL to your website out of the MLS, and then you would have a link to click from there. So before I move, I know this is important. We get a lot of questions on this. Does everybody understand what I'm saying? The 2 clicks off of the MLS to your compensation offers if you're going to put them on the internet. If you have a question about that, go ahead, put it in the chat, raise your hand, or just unmute yourself. All right. So the other big change, of course, is the requirement for written buyer-broker agreements. And those agreements must specify and conspicuously disclose the amount or rate of compensation And how it will be determined. The amount of compensation has to be objectively ascertainable and may not be open-ended. So you cannot write into your agreement whatever the seller is offering. You've got to be specific in the buyer-broker agreement, and we're going to go through that in the forms. And then, of course, realtors may not receive compensation for brokerage services from any source that exceeds the amount or rate agreed to in their agreement with the buyer. But these all, the listing agreement, the buyer-broker agreement, all these things can be amended. And of course, as we go through the closing process, we can expect that they will be amended. So there are other terms of the settlement. The big one that got us into this mess in the first place is you can no longer say that buyer services are free unless they are in fact free, which means that the buyer's agent is receiving zero compensation, and no one works for free, so that will be an odd case. And then the other part of it is that listing agents must conspicuously disclose to sellers and obtain sellers' approval for payments related to buyer broker compensation. It has to be agreed and provided in advance, and it has to be specific. And then, of course, you have to disclose to prospective sellers and buyers in conspicuous language that broker commissions are not set by law and are fully negotiable. So you're going to see those terms in all of the contracts going forward, that the phrase that we're going to go over for buyer commissions are not set by law and are fully negotiable. And then, of course, you cannot filter or restrict MLS data by compensation offered. That's going to be pretty hard since there will be no compensation in the MLS. All right, before I get into the form specifically, do we have any questions so far? Okay. So let's talk about the NABOR buyer broker exclusive agreement. We're going to walk through it.
Sorry, Sam, can I interrupt you? You said something about this 2-click. I understand it will take 2 clicks to get to the PDF, but what exactly and where exactly would you put the link in the MLS, if I'm understanding?
They're calling it a link, but you just put your URL in the confidential remarks so that the other agents can see that you're offering concessions.
Okay, so it's a URL link in the confidential remarks, which would then go to my landing page, which would then give them a link to a PDF.
If that's how you choose to do it, yes.
For example, but there's your two clicks. Okay, yeah, thanks.
You got it. Okay, that's very important that we don't. And by the way, all of the MLSs have agreed that their fines will be heavy and there will not be warnings. I believe the last information I had was from the Royal Palm Coast, which was part of the co-op, and it starts at $1,000 and goes up from there, including meetings with brokers and as much as $15,000 in some instances. So very hefty fines by the MLS. They're not screwing around, so you need to be on your game. Okay, buyer broker exclusive. So of course, buyer broker exclusive agreement. Actually, you've got your buyer, put your name here. This is different from FARBAR that you don't put the consumer. They're calling it a consumer in FARBAR world. Here we're calling it the buyer still. And note that it's an exclusive agreement. Oops, apologize. Then the broker's name goes here, and you would put the full name of your broker. You do not want to put the short name or the abbreviated name. Put your full name, including Anchor LLC, so that we know who we're dealing with. Then we get into the broker's role, paragraph 1. The broker is retained to assist the buyer in acquiring an interest in or right to use residential real property, and it defines what you're going to do for the buyer. You are going to consult with the buyer to discuss property requirements, financing alternatives, possession, time schedules, financial capabilities. Highlighting financial capabilities for a second, let's make sure that we all have a good relationship with a lender now, because the lender rules regarding compensation and concessions are going to be more important. So let's plan for that. And then, of course, you're going to deal with strategies and negotiation issues. You're going to assist them in obtaining information related to the property. You're going to help them make offers, and then you're going to monitor the closing process. And these are things you need to tell them that this is your value. This is what you do up front. So make sure that we make sure that that happens. You're going to pick your brokerage relationship. It used to be a blank line. Now, of course, you have a checkbox: transaction broker, single agent, or no brokerage relationship. Make sure that you talk to your broker and understand what you're allowed to choose. I know many of the large brokers insist on you being a transaction broker. So check the box. And of course, transaction broker is the default if you leave it blank. What is the buyer's role? Well, the buyer, number one, agrees to work exclusively with the broker and be available to evaluate and view properties exclusively with the broker and not any other broker, licensee, owner, builder, etc. So I think it's important that you have an exclusive relationship to earn that compensation. If you have a non-exclusive relationship, you're asking for a fight with your customer when it comes time to getting paid. And I just want to make sure that we don't have that problem. Okay, so they agree to refer all inquiries from any source to you. They agree to provide reliable information about themselves and the desired properties and notify other brokers about the existence of this agreement. Since it's exclusive, if they were to sign two of them, they really could be in a situation where they pay two commissions, but you also are going to be in a procuring cause fight. So you really want to make sure that you have them notify other brokers about the exclusivity of this agreement. Will is asking a question: can you amend the buyer broker agreement if the sellers are offering more than what is on your buyer broker agreement? You can amend it, Will. Yes, you can. So what is the term of the agreement? You have to pick a commencement date and a termination date. If you do not pick a commencement date and a termination date, then 180 calendar days from the date it's signed, which they're calling the commencement date, is the term of the agreement. So you would have 6 months to find them a home if you didn't fill a date in. The other really important part of this paragraph 4 is the protection period. Under the protection period, if after termination, the buyer enters into a contract to purchase or lease any property toured by buyer during the term of this agreement, that's the operative phrase, toured by buyer. Let me highlight that for you because it's really important. And we're going to talk about touring, of course. Toured by buyer during the term of this agreement, the buyer will pay the broker's compensation as set forth in the agreement. So if you take somebody out, you show them a home and it's for a weekend and you have a short term, for example, on your buyer broker exclusive, and then they go back and try to buy a house that you toured with them under the NABOR forms, you are entitled to the compensation. If you sign a contract for the purchase of the home, and then the term expires, it's an automatic extension until the closing or termination of the contract. So compensation amount. How much are you going to be paid? Well, of course, you have 3 choices for purchase, and you have 3 choices for lease. But let's start off with what I said at the beginning here. Broker compensation, real estate is not set by law and is fully negotiable. That's going to be on all the forms. So get used to seeing that and explaining it to your customer. What does it mean that it's not set by law? There are no percentages or amounts that are required to be charged, and you have to negotiate it, and you should be prepared to do that. You would check the box for the type of compensation, whether it's going to be a percentage and a dollar amount, and you check this box for dollar amount, or just a flat fee or other. And then if you're also going to be leasing or looking for lease property for them, you would do the same thing below. Okay. Cheryl is asking, does this cover virtual tours as well? Yes, it does. Cheryl, touring the home if you are quote unquote working with the buyer and touring the home, then you need to have a buyer broker agreement signed. And then Jennifer is asking, does the buyer broker need to be modified at any point in time prior to closing? Once we're closed, then we're done, Jennifer. So I would say if you're going back and forth, you would get it modified. And then the question is, do you have to have a line through or a form? And the answer is whatever you're comfortable with. NABOR is going to be providing a blank form for amendments. We're going to show you that here in a few minutes. And then the alternative is to line through your compensation, change it, initial and date. Rosemary is asking, what if the buyer signs 2 buyer broker agreements? There's a very good chance they're going to pay 2 commissions, Rosemary. If they forget or don't mention it or they're unaware that they signed something, there's a very good chance they could pay 2 commissions. And then Darlene is asking, would a buyer have any reason to refuse to amend the agreement to allow you to be paid more than was originally agreed? Absolutely, Darlene. A buyer may refuse to have you be paid more. They may want that money for themselves. They may want to split it. So yes. And then rentals, Annette. So this NABOR form covers rentals as well. It's not required under the settlement for rentals or commercial property, but the settlement does require it for vacant land 1 to 4 family, which is how residential is defined under Chapter 475, but not for rentals and not for commercial. Okay. So what are the compensation terms? Well, the compensation is earned when placed under contract. So you earn your money when you place the property under contract, which I think is an important point. You get that contract signed and you've done your job. You're not done yet, but you've at least done the bulk of it. You're paid at closing or upon occupancy or upon default. And the broker can negotiate for compensation with the seller. If the seller offers concessions but no compensation, then the concessions may go towards the broker for compensation. And if you think about that point, you know, if the seller is offering concessions of X, you have a compensation agreement for something like X. It doesn't matter to the buyer because buyers really care about how much they have to bring to closing and what their monthly payments are going to be. And we will be doing net sheets for buyers, closing cost assessment, sheets for buyers, so they can see what they're going to bring to closing. And if somebody comes from concessions and has to go to compensation, that's allowed under your buyer broker agreement. Kevin, that's an excellent question. Does the transaction fee need to be on the buyer broker as well, or is it okay to put in the contract for sale and purchase? It should definitely be in your buyer broker agreement. If your brokerage asks for a transaction fee, a technology fee, a brokerage fee, a compensation fee, whatever they call it, put it in your buyer broker because you can only be paid, and it's the broker that can only be paid what's in the buyer broker agreement. And if the buyer pays the difference, if you've negotiated X and the seller offers something less than X, it's very clear that the buyer pays the difference, and you cannot be paid more than what is in your written settlement agreement. Okay. Sharon is asking, I have a question regarding earned once property is under contract. Under what circumstances may that not apply? Maybe better if I speak. Sharon, so the property has to close. Whoops, right here. The property has to close for you to get paid. If I can just find that phrase. It's in here somewhere, but the property has to close for you to get paid. If you were to, for example, the buyer were to terminate under an as-is contract, you wouldn't get paid. But if they defaulted on a contract, then you would be owed the commission.
Okay. And if the seller defaults, then I guess it just would be pretty bad practice to charge your buyer at that standpoint. So if
That
the
would be
buyer,
a decision that your broker would make, but if
okay,
the seller defaults, typically there's an opportunity to collect money from the seller, just depending on the situation, you know.
Got it. Okay, thank you.
Yep. Okay, sorry. Okay, so I see a lot of questions coming up. Is the buyer broker agreement, is the broker signing the buyer broker agreement, the agent? Cheryl, another excellent question. You need to talk to your broker. Your broker should authorize you to sign the buyer broker agreement if that's what they want to do. I would like that to be done in writing, something more than an email, maybe a policy manual change, however your broker communicates those things. But I think that brokers and agents need to have a serious conversation about who's going to sign these, and brokers should have a policy in place. I know at least the large brokerages, that's what they're going to be doing, and all the small ones, I suggest you get a written policy as to who can sign what, for listings too, by the way. Okay. So let's see
Hey,
here.
I have a question if you're available.
Yes, Christina, go ahead.
Okay, thank you. You said they're going to be doing buyer net sheets. So
I'm
once you
going to be doing them, yes, for
you're
agents.
gonna be- okay, so let's just say you have a BBA, everything is signed and sealed and great. And you did not denote that concessions from the seller could go towards commissions because you can't do that, right? And then the seller sees the buyer sees the net sheet and says, you know what? I think I'd like to change that. As long as your BBA is in place, we're good to go, right? For our commissions. They can't change it at the last second because they see now that their closing fees are going to be more and they want to denote.
No, the buyer broker agreement is a contract between you and the buyer. That's one of the arguments for having it signed earlier in the process. If the BBA is signed early in the process and you're at X and you get them a house, you get X. You know, if you must have one prior to touring a home, but as you know, a lot of people don't come down here. They do sight unseen. If you do a virtual showing through FaceTime or something, then you would need a buyer broker signed. But for the sight unseen buyer, they aren't required to sign these. I expect there to be a lot more problems because of all the press. So I would get one of these signed early in the process.
Thank you.
You never know how it's gonna shake out. Okay, let's look. Questions. Joan is saying, what buyer form should you take to a listing appointment? Joan, if you mean a listing appointment that you go to talk to a seller, the listing agreement now has, and we're going to go through that today, the compensation and concession offers in it. So we'll talk about that. And then Deborah is asking, Florida Realtors listing agreement paragraph 8 through 10 uses compensation. How are terms different? They're not. Compensation and other things. Deborah, these agreements all work fairly similarly with a few tweaks. So,
excuse me, Sam, Joan
Yes, Joan.
Crumpton here. No, but so say you have a listing appointment just to get, so when a broker calls me and they want to show the property, I need to have a form signed by the seller, correct?
Broker, so you got the buyer, you mean?
No, so I have the listing and
Right.
and they see that it's paying a 3% commission.
No numbers, say X.
X.
It's paying X.
Say it's paying X. They're going to show the property. Don't I have to send something saying that we're offering this to them?
The astute buyer's agent's going to ask you what the compensation is, and you're going to negotiate it with them prior to touring the home. If they've signed a buyer broker agreement with their buyer, then whatever they've agreed to with their buyer really doesn't matter to the seller, because the buyer is going to be responsible for X, whether the compensation is partially paid or fully paid by the seller is something that can be negotiated through the process.
Oh,
But
so there's
when
not
you go
an
on a listing
additional
appointment,
form.
you need to explain to the seller. You're going to say things like, seller, to make your property more attractive, you should consider offering compensation to a realtor who brings you a ready, willing, and able buyer. Do you want to offer compensation to this realtor? If they say yes, on the listing agreement, you will now check the box and put the amount of offer of the co-broke right on the listing agreement the way you always have, and concessions are dealt with separately.
Okay, thank you.
Yes. Okay. Okay. Questions are coming
Sam,
in.
one more thing, that
Yes, Jennifer.
part about that's up on the screen about seller concessions being used towards the competition.
Yep.
That what if so if they're offering a concession for something else, say they're offering 40 grand for a new roof, and it seems like to me that there's some confusion there, that a
There is some
buyer.
confusion there. It is difficult to understand, but if you think about it, the way I try to think about it is money is fungible. If the buyer is going to pay X for the property, and they're going to pay, and the seller is offering something for a new roof, and you have a compensation agreement, a buyer broker agreement in place with the buyer where they're going to pay you X, it doesn't really matter. The seller's going to put in for the concession, and the buyer's going to pay for the compensation that they agreed to. So it all nets out to the buyer, whatever the buyer has to bring to closing. That's why I foresee that I'm going to be doing a lot of buyer draft closing statements. We won't call them net sheets, because that's really for sellers, but buyer draft closing statements, so the buyer can see what they're bringing to closing. And they're going to then want to negotiate the compensation with the buyer's agent and the concessions with the seller. And then the concessions will go in the sales contract, and the buyer broker compensation will go in the buyer broker agreement and be told to the closing agent at closing. That's kind of how I
Right,
foresee this going.
Yeah, I know, but if the seller's actually offering both, say they're offering buyer
Concessions
broker
and
compensation,
compensation,
and
that's
they're
great,
offering
but
a concession,
yeah,
you can't, there's like no way to, there doesn't appear to be a way to keep them separate, because
well, they're
of
not
words
separate to
we
the
can
buyer.
and can't use.
They're not separate to the buyer. The buyer doesn't care. The buyer just wants to know how much they have to bring to closing. And if you're with a first-time home buyer, for example, or someone with not a lot of cash, but they've got to buy because they're moving, for example, then they just are going to want to know, how much do I have to bring to closing? How much do I get in concessions? How much do I owe in compensation? How much is my down payment? And how much are the closing costs? And so the conversation is going to be about, I foresee being more about, what is your bottom line cash to close, and how do we get to a number that you're comfortable with? I mean, do you see what I'm saying? Am I saying it wrong?
Yeah, I mean, I do, but holy mackerel, I think they're just going to be more confused than ever.
I agree that this language in NABOR's contract is a little bit confusing, but it is technically correct. So I'm not sure that I could have improved on the language. I was not on the subcommittee that drafted this, but I'm not sure that can be improved much, because money is fungible, and that's why the buyer doesn't care one way or the other. All right, let me get through some of these other questions. Let's see here. If I'm the listing agent, I also have the buyer, and the listing agreement is before August 17th with a co-broke, but buyer is after August 17th. The buyer broke agreement for total amount in the listing. No, Linda, the buyer broker agreement is going to be negotiated with the buyer for whatever compensation they're paying. And you're going to, if you have both sides, you're going to know what the co-broke is. And so if you have the seller's permission, which you will in the listing agreement itself, to offer the compensation, you can say something to the buyer if you're going to be sharing that with them to get them into the deal, or you would just get the full amount of the compensation offered in the listing, because you have both sides. Rosemary is asking for seasonal rental agreements. Do you need this signed also? No, Rosemary, this is for residential and residential vacant land sales. Linda is asking, is my relationship with the buyer no brokerage relationship if I'm the listing agent that also has the buyer? Linda, that's a great question. And you could either be no brokerage relationship and owe the 3 duties, or you could be transactional to both and owe the 7 duties to both. Is that a question? Somebody have a question? A couple people are unmuted. Okay.
I do. Jim, I have one question.
Yes, Darlene.
I'm looking at bullet point number 4, 1, 2, 3, and the last one. And I want to say if the seller offers concessions but no compensation, concessions go to the broker for compensation, but that compensation cannot be more than what was already agreed to in the buyer
Correct.
broker agreement?
That's
Okay.
right.
Because
But
I got
again,
the
that goes back to what we were talking about earlier. If you have a buyer broker agreement for X and the concessions are, for example, more than X, then the buyer's getting the concession, the full amount of the concession, you know, assuming there's no loan issue where they're limited by their IPCs. But the net out, you know, cash to close to the buyer isn't going to matter or isn't going to change because you are still owed X.
right. So
So
whatever
when
we
I'm doing
agreed to,
when I'm doing the closing statement, the buyer is going to be worried about how much they bring to closing, which is going to include, you know, the compensation, the closing cost, the net amount of the purchase price, and it's going to be less the concessions. You understand?
okay.
And maybe in a
So
future webinar I can put together like a draft closing statement for everyone to see, so you kind of see what I'm talking about.
yeah, it's just odd. Concession, compensation, these
Right, they're
words,
totally
and
separate. They've always been negotiable, and now they're going to be fully and clearly negotiable.
yeah.
They
So if
just
there's
need
a
to-
$40,000 roof concession that goes to the buyer's already agreed to pay me X. There you go.
Yep.
Like
That's
I
right.
think I get that now. Okay.
Okay. All right. Mariana is asking, what if they want to change compensation because of the lowball offer in their mind? They want to accept no other way to buy around, but okay, Maureen, we don't want to use numbers even in our comments.
Yeah, I had this lot for sale, and I knew how much there was the compensation before because it was a week before. And when we came 20,000 lower, they want to get me to 1%. And
You should plan to negotiate your compensation as part of the deal. That's exactly what this settlement is forcing us to do. So if they may have a compensation, the seller may tell the listing agent, I'm willing to pay X, but the listing agent may want to get a better deal for their seller, and the seller and the listing agent may have a conversation about that, and they may tell you that the compensation is going to be something less than X, especially on a low ball deal. And that is kind of the way it's going to go. I foresee a lot of compensation negotiations and concession negotiations, especially on as-is contracts throughout the process. I'm actually a little scared for me as the closing agent because I've got to deal with it and get it all correctly on the settlement statement. But I foresee a lot of back and forth between the realtors as you're trying to get the deal done. But once it's signed up and everybody agrees, then we just go to closing.
Okay, so they can change it anytime when they feel, well, we can squeeze at least some money out of the agent.
Buyer. Yeah, the agent, of course.
Because
yes.
at
And
the
that's
end,
why you want to
agent
use.
who has to leave some money on the table if we want to make the deal at the end, somehow in a way or in another. That's a little bit
It's possible that could happen. And but you will want to get the broker to broker compensation agreement signed to lock in the commissions once you have reached a deal.
Yeah, that I have, but I was wondering if they are not obliged to have this addition when the 3% or 2% or whatever they had on the MLS, when they had to make an amendment to the MLS listing, that they still make a compensation. And now they made that. And now during the discussion of the price, they changed that again and again. So you can at least change that whatever you want. At the end, you can say 0, even if you have an amendment.
You can always, again, until you get it signed, it's negotiable.
Okay.
It's got to be in writing. It's got to be agreed to obviously by the realtors and by the buyer and seller.
Okay.
So it's going to be changeable. Yes.
Excuse me, Sam, Joan Crompton again. I
Joan.
had a for sale by owner pocket listing that they agreed to sign a 5% commission
Okay, let's use X.
agreement.
Yep.
And I brought an offer for less than what they wanted, the buyer was willing to pay me a 3% commission.
Joan, use X, hon. Don't use numbers because I don't want us to get in trouble.
Oh, okay. So now there's a significant commission on both properties. Am I entitled to that commission number, whatever it is?
You mean on both sides?
Yeah.
Oh, well, that depends on your agreements, what they say. Does your buyer broker agreement say that there's an offset? If you use the NABOR form, then it does, or the FAR form, then it does. So you'd probably be entitled to what the seller offered you, and the buyer would not pay unless he was charged more than the seller. Sounds like, based on what you're saying.
Okay, all right. I have to look at that form. The form is new, but it is a transactional broker form.
Well, the
no
brokerage relationship wouldn't control that. It'd be the language.
Can you put that form up?
No, I don't have it in this slide deck.
Oh.
But I'll give me a call afterwards and we can walk through that scenario too if we have to.
Okay, thank you.
Yes, ma'am. All right, let's see here. So I got a few more questions. So a good question, Adam. When is the best time to have the broker-to-broker agreement signed with the offer? I would say, Adam, it depends on how you're negotiating your deal. That's a great question. We're going to talk about that when we get to the broker-to-broker agreement. But when you send the offer, maybe the appropriate time, or maybe before, or maybe when you reach a final agreement on the number, and that includes the broker-to-broker compensation. It will just depend on your negotiation and the listing agent and your relationship, and how, if you want something locked in prior to sending the offer, that's going to be a tougher situation. They may not want to do that, but that may make you more comfortable. So again, this is the number one question that I'm getting as I do these presentations, is when do I find out how much I'm going to get, and when do I lock it in? And I think you're going to be negotiating this until you give a solid, firm offer that the seller is ready to accept. Jennifer is asking, any thoughts on MLS? Not only to use words like concessions or credit. Mark almost wants to use dozens of different words. Jennifer, I'm not going to get into realtor politics. This whole thing is a mess, and it's going to be a lot of shaking out. But I think that they got to comply with the settlement. So we'll see how the boards end up handling this. All right, let's keep going. Oh, one more question. Deborah's asking, what happens with the differential amount if the buyer agreement is not as high as offered, and how is it handled in writing by all parties? You would get the lesser amount, Deborah. So if the seller is offering X and your agreement is something less than X, you get less than X unless you amend. And then you're talking to your buyer about you getting more money and everything that includes. And Yola, yes, the sales contract are gonna be changed to reflect all this. We're working on that now. Okay, let's keep going.
Does the seller keep the difference if that happens?
That would depend on what they've negotiated. The seller has agreed to pay what they pay in the listing agreement, so it probably goes to the listing agent. That's what I was thinking. But again, it'll depend on the listing agreement and how everybody has agreed under those terms. Okay. So the scope, this is a very important. This agreement is only applicable to residential property located in the following counties. If you leave it blank, it's the 3 counties. So make sure you know the geographic area that you're going to be working in. That's going to be important. The default, if the buyer defaults under any contract to purchase or rent, or otherwise breaches this agreement, that's the buyer broker agreement, this agreement's not terminated and remains in full force and effect, and the broker gets all the remedies, including a lien on the property that they may buy, to recoup the compensation. Now, this is controversial, but a lien on the property does not mean you run down to the courthouse and file a lien and you get your compensation. You're going to have to sue the buyer, get a judgment, and then you can lien the property. So it's not a simple process, but you would be at least entitled to get your compensation eventually. And then, of course, the buyer holds the broker harmless for referrals. Other terms included, the fair housing requirements are still in place for buyers, and this is a very important change. Buyer elects or declines to be shown properties where no concessions are being offered. If your buyer needs the concessions to close, the first-time home buyers, the young couple that just got the baby and they need to get the house right away, those types of people who don't have a lot of money, if they need concessions, you can elect to filter by no concessions. And that's not a violation of the settlement agreement. Okay. And then Jim is asking, several new construction contracts that were signed this spring and closing in the fall and winter. Are there any additional forms needed since this preceded August 17th? Jim, absolutely. I would get buyer broker agreements signed in all those cases because you are going to want to make sure that you get your bonus and everything else that comes with new construction. Okay, there's a few more terms. Very important. Notice to no outside promises. So all those text messages and emails you have back and forth with your buyer about the compensation are not relevant in court when we have to fight about the compensation. It's only what's in the buyer broker agreement. So make sure that you get your compensation correct in the buyer broker agreement. The broker can assign this. All changes to this agreement have to be in writing. And very important now, notice to a licensee shall not constitute notice to the broker. So what does that mean? That means that your broker has to be properly and independently notified of a breach of the contract, if you breach the contract. So it's important that the proper information to the agent beyond the contract. Lastly, we have our wire fraud notice. Of course, very important that we not exchange wire instructions. This has saved one large brokerage from paying a lot of money in a wire fraud case already, so that's very, very important. And then, of course, the signature blocks. You've got the buyer's information. The line is missing here, but there should be a mailing address, telephone numbers, and an email address so we can give notices to the buyer. And the notice down here, authorized broker's signature. NABOR assumes that the broker is going to assign this. FarMar does not. The licensee prints their name here, and then you put your full brokerage name here and your mailing address for notices of the brokerage. The broker's mailing address goes on the bottom line. Everybody see that? Please don't skip the addresses. Where my mouse go? Okay, oops. Any questions on the buyer broker agreement? Will is saying, I heard you say concessions, but if the buyer can't buy, does this apply to commissions as well? I'm not sure what you mean by that, Phil. If you want to unmute yourself, let me know. Laverne is saying, if my seller agrees to have me share the compensation, am I required to give a 1099 to Realtor representing the buyer? So if I don't, no, you are not. No, this would not necessarily be a 1099 situation. No. Vivian is asking, if you have the listing and buyer and you're offered the seller a variable rate compensation, if you bring the buyer, will your buyer broker agreement need to reflect variable compensation listed on your listing agreement in order for you to collect the total? So I think the variable rate stuff is coming out of the listing agreement, Vivian. We're going to get to that in a few minutes. I didn't see that in there like it used to be. So I don't think you're going to be doing variable rates anymore. If you have one now, you would still need, you should have the, you would still get the variable rate, I think, in your current listing agreement. Okay. Christine, you have a question?
No, I'm sorry.
Okay, let's meet you. All right. So when you have to amend your buyer broker agreement, this is the form. NABOR is providing a blank form. You will write in your amendment here if you choose. And I personally would like to see a cross out, an initial, and a date with a new compensation on the buyer broker agreement, but if you want to write something into this amendment, something along the lines of the buyer broker compensation shall now be Y, and you put your percentage or your dollar amount, and don't forget to put your transaction fee in there if you do make an amendment. So just notice that. Will, you're asking, can you put additional terms the buyer can't pay because they can't pay commissions? Can you put that in the agreement? You absolutely cannot filter by compensation, Will. Do not do that. You cannot just say, only show me homes that offer buyer broker compensation. That is a huge no-no and gets everybody in trouble. So you cannot filter by compensation. You can filter by concessions, but not compensation. Okay, so this is the two forms that the buyer can sign for NABOR, but there are several other forms that we need to talk about today. Next up is going to be the NABOR showing compensation agreement. So you're going to have situations, there were a lot of changes to the showing agreement, and we're going to go through what my form. Have my notes here, give me a second. Yep. Okay, so you're going to see a lot of changes in this form if you're familiar with this form from before. I'm not using the red lines, so the line numbers are all off and they're hard to read. So we're just going to use the new forms. First off, you put your seller and your broker information. Again, please use the full name. If you've got a seller that's a trust or an LLC, please don't abbreviate. Please make sure that you use the full names of your seller and your broker, and then enter the property address here. Will is asking if the buyer's paying commission, is that on the settlement statement? Yes, it is. So it'll always be on the settlement statement. All right, so under the showing compensation agreement for sale, no brokerage or agency relationship. Remember, you're no brokerage relationship. So you put the purchase price that the seller will sell for. You put the notice, give the notice of no brokerage relationship. So if you use this showing agreement, there is a separate form that you must give your seller. That's your no brokerage relationship notice that NABOR provides. You still owe the statutory duties to deal honestly and fairly, disclose all known facts and material affect the value of the property, and account for funds. Don't forget, on this disclose all known facts, you have a separate duty from the seller, so don't let them tell you not to do that. Dick, you had a question? Okay. Broker compensation and commissions are not set by law and are fully negotiable. That's going to be again in all your forms. Notwithstanding, the seller agrees that if the broker procures a buyer who's ready, willing, and able to purchase the property, they enter into a contract within so many days after the date of this agreement, then the seller will pay the compensation. And this is again is like your protection period. So you've got the purchase price percentage and a fee or a flat fee or other. And then, of course, this agreement extends through closing. So this is the amount the seller is going to pay. This is the amount the seller pays, even in a no brokerage relationship, if you bring the buyer. It's a very short form. If there's a default, the seller owes the compensation. And if this is a new addition, if the deposits are paid by the buyer after termination of the contract, then you get a percentage. If you don't fill this in, you get 50% of the deposit up to the full amount of unpaid compensation. So it's kind of like the listing agreement. This was added to that. Okay. I don't see any questions about that. So we'll move. Oh, when do we use this? Exactly, Jennifer. FSBOs, unlisted properties. That's exactly correct. This is for FSBOs and unlisted properties. If you'd rather have a full listing agreement so you can advertise and get the highest price possible. But if you've got the buyer and the seller is willing to pay a compensation, you would use the showing agreement. Dawn, that's an excellent question. I'm going to read it. I have the listing agents tell me the seller concessions will depend on buyer offer. They are not sharing that percent up front. Is that okay, or are they supposed to share the concession up front? Dawn, I believe that realtors should work together to get these deals done for their customers. But I guarantee that listing agents are not going to be sharing the compensation and concessions up front, because they're going to want to see the offer come in and make sure they're not getting lowballed, because they're also going to be talking to their seller about their net. And that's what the seller cares about, is the seller's net. And they're going to want to know, what am I paying the other realtor up front? So be prepared for that.
So Sam, with
Yes,
that,
Christine.
with that example, the listing agent would simply say the seller decides at this time not to disclose that. And
That's a
it's
good
fine.
phrase to use. The seller would like to see your offer before disclosing any compensation or concessions. Yeah, a friendly phrase. I don't think we need to be rude about it. A friendly phrase like that is perfect.
Not go pound dirt or anything.
No, I'm not sharing nothing with you. Let's keep it friendly, because the
Okay.
next several months for all of us are going to be a little rough as we adjust to this.
Thank you.
You're going to get a lot of buyers. I'm not signing anything. I don't know you. I don't want to work with you exclusively. The Debbie is asking if the listing agreement should be shared. No, these agreements are probably not going to be shared with other realtors. These are between your broker and your customer on the listing side and the buyer side. I know that some lawyers are saying, I want to see all the agreements and I want to see this, that, and the other thing. I can tell you, in my office, we already have the agents, the brokers sign off on the compensation on a commission verification form. We're going to modify ours to clarify who's paying for what. But that's what we're going to require. Then we're going to obviously put the exact amount of the correct compensation on the closing statement, and the buyer and seller will sign off on that. But I don't think that the buyer broker agreement or the listing agreement need to be shared amongst the parties. I think that's going to create a lot of unnecessary friction, and people aren't going to want to do it. Now, if you want to share it, great. I'm not telling you not to, but I'm just saying I feel there's going to be a lot of reluctance to do so. And I'm okay with that from a closing perspective, because you're going to sign the commission verification form. Debbie, I think I answered your second question as well. You can unmute yourself if you have another one. Okay, so just going through the showing agreement here. You got your signatures, you got your other terms and conditions. The broker signs, the brokerage name, the licensee's name, and of course the seller's sign and date as well. So that's the showing agreement. That's what the seller signs in a no brokerage relationship, non-listing situation. And that's how you get paid from the seller side, if, for example, if you had the buyer on a FSBO. Okay, so then it was asked earlier about the NABOR broker compensation agreement. This is between the brokers. And this is what it looks like. It's one page. We're going to zoom in on it in a second, but I want you to see it in full first. You've got your listing broker, your buyer broker, your property, your buyers, your compensation, and your terms and your signatures. Let's zoom in and take a look. The listing broker puts their full brokerage name here. The buyer's broker put the full brokerage name here. I'm going to repeat myself from the beginning. Please don't abbreviate. If you work for ABC Realty, put ABC Realty Associates Incorporated or whatever your full name is. Don't just put ABC on both sides, because I've got to get it correct for my closing, so I make sure that the money goes to the right place. And God forbid we have to sue each other. We want to make sure we sue the right franchise. So, okay, you put the following described property, address goes here. And then you put the buyer's name here, because this applies to this buyer. And this is under NABOR. FARBAR has the buyer name optional. NABOR does not. And then the listing broker puts in here that they've entered a representation that they've entered into the listing contract with the seller in order for the listing broker to provide brokerage services. Of course, that's a statutorily defined term, where the seller has agreed to allow the listing broker to provide compensation to a buyer's broker. The listing broker agrees to pay the buyer's broker compensation equivalent to the following, and then you fill it in. And it's of the purchase price, percentage of the purchase price plus a fee and or a fee or other. And this is paid upon closing with the buyer during the term of the listing contract or any extension or protection thereof. And don't forget the and. Buyer's broker is the procuring cause. So you have to be procuring cause to get paid. And I foresee a lot of procuring cause disputes in the future. So much so that I'm buying my old brokerage handbook. I'm updating it. Questions about the compensation? This is between brokers. Jennifer is saying I had a buyer agent asked me for the broker to broker before they even shown the property, and timeline in this just before an accepted offer. Jennifer, again, this is going to be a matter of negotiation. I personally would like to see the agents get along and talk about the compensation up front, get it in writing, use this form, the broker to broker form, so that everybody knows who's getting what up front, and then you bring an offer, and as best you can, you negotiate based on all the other conditions in the offer. I don't think that's going to happen necessarily. I think that the compensation and concessions are going to be negotiated throughout the offer process. You'll put the concessions in the sales contract and the broker to broker comp in this form.
Hey, Sam, it's Darlene.
Yes, Darlene.
It was suggested that if the seller is agreeable, and this is all in writing, that you actually put this broker to broker agreement right on the breakfast bar, so that when they're touring, it's very obvious that, you know, the seller is allowing, you know, to provide compensation. So it's,
Sure,
you know,
I've heard
again,
people say they
play
wanna-
nice.
I've
Yeah,
heard,
play
I've heard people
nice.
say that,
You know,
and that's great. I would love for that to happen, but I just see sellers wanting to get the best deal possible and paying as little compensation as possible. And if they can modify and negotiate the buyer's side of the compensation for a low offer, that's going to happen.
yeah, yeah. Anyway, just for what it's worth.
Yep.
Yep, I have a question.
Yes, Christina.
Thank you. If you're using this form, right? Let's say both brokers sign,
Yep.
they're in agreement, and then all of a sudden the buyer says, well, if the seller's offering that money, I don't want it to, let's say, for example, you're getting X on your agreement with the buyer,
Right.
right? And you have a buyer to buyer agreement, right? And you can't get paid more.
Right.
But if there was monies left on the table, could the buyer at that point say, well, irregardless of you having that agreement with agent to agent, those extra funds will go to me,
As a
or
concession, you mean? That absolutely could happen. Yes.
okay.
Yep. I think it's going to be tough for buyers agents, because if the compensation offered does not immediately match the compensation agreed to with the buyer prior to touring the home, then there's going to be a negotiation of the compensation to the
Okay, but
buyer's agent.
again, this is a good thing that you weren't sure,
Say it again, Susan.
okay?
Susan?
Hmm.
I can't hear. All right. So again, you're paid at closing, must have written modifications. Arbitration is required under the National Association of Realtors rules if you have a dispute. And then you must give a copy of this agreement, not necessarily your buyer broker or your listing agreement, but you must give a copy of this agreement to the buyer and the seller, because the settlement requires that the compensation be disclosed to both parties. So be mindful of that. The buyer and seller will know the compensation that each is paying to the other. So that is just part of the settlement. Okay. Yola has a question. Concessions, Sam, I attended the webinar last week, but there was a form introduced regarding the concessions to buyer. The seller and buyer need to agree and select a specific box and sign the form if concessions are going to buyer's agent. Question is, if buyer is accepting seller's concessions, can't buyer just make a decision? The concessions be used as buyer broker compensation without seller approval in writing? I know they cannot, Yola. The settlement agreement and now the listing agreement say the seller and the buyer broker agreements agree. They say the seller's got to approve the compensation. That's in the settlement agreement. So again, this broker to broker form is probably going to be negotiated between the agents and then shared with the parties as part of the, in my view, hopefully done and part of the beginning of the transaction.
Could
So
you
we know
repeat her
who's getting paid
question,
what.
Sam?
Yes, Christina.
Could you repeat her question and the answer again? I'm sorry.
It was a long
Confused.
question, but the question essentially is, if buyer is, and this is in the chat, by the way, if buyer is accepting seller's concessions, can't buyer just make a decision, the concession to be used as buyer broker compensation without seller's approval in writing? And the answer is no. The seller must approve the compensation in writing. That's why it's in the listing agreement. Okay, Maureen, is that even right? A full price offer, so could it be negotiable also for the concession? Marianne, I'm not sure what you're asking, but you can unmute yourself and ask. Vivian is asking if some of the seller's compensation agreed to on the listing contract is going to go to the buyer at closing. Would you recommend the seller acknowledge this in writing prior to closing, because the seller may not be happy the buyer receiving compensation which seller meant to go to the brokers? Vivian, I think you're confusing two things. The seller will know the compensation offered to the buyer's broker because they have to approve it in writing on the listing agreement. They will also know the concessions going to the buyer because they will approve it on the sales contract in the offer and in the final sales contract. So don't forget, concessions are going to be in the sales contract because they're between the buyer and the seller. Compensation is between the brokers from the seller or the buyer, depending on the amounts, to the agents.
Sam?
Yes,
I'm
Vivian.
sorry, I think okay, I'm gonna try to explain. If there's an overage because the buyer broker agreement is for X and it's less than what the listing was offering, what the seller was offering in compensation to the broker, so the buyer is gonna get it now at closing.
If the buyer is agreeing to give you X and the seller is paying something more than X, then what happens to the overage depends on the listing agreement, but it does absolutely not go to the buyer's agent because the buyer's agent can only receive the X in the buyer broker agreement.
Right, so if it ends up going to the buyer, if the overage ends up going to the buyer, I could see a lot of sellers getting upset when they realize that.
Why would the overage go to the buyer? I mean, I think it would go to the listing agent.
Okay, see, we had a class last Monday that the attorneys said it would go to the listing agent, and our brokerage said they called those attorneys and talked about it, and the attorneys said that, yes, they were wrong, that it has to go to the buyer. It can't go to the listing agent. So this
I don't know why. I'm not sure I understand. Either I don't understand the scenario or I don't agree with the conclusion, because the listing agreement, as I'm going to show you in a few minutes, says the seller agrees to pay compensation and then they agree to share the compensation with the other agent, with the buyer's agent. So the top line number hasn't changed. So I'm not, so the seller's on the hook for their X, whatever they agree to in the listing agreement, regardless. Let's get to the listing agreement in a few minutes and we'll revisit this. Okay, so again, the listing broker and the buyer's broker sign. By the way, it's no longer cooperating broker or listing or selling broker. NABOR is going to call it buyer's broker on all forms. So there was some confusion and some inconsistency that's being corrected. It will be buyer's broker on all forms. So just know that in NABOR land, it's buyer's broker and buyer on all forms. So print your information, your broker name, your brokerage firm name, the licensees go here. I don't know why the lines are missing. The licensee goes there, and then the broker signs. And again, in NABOR, they expect the broker to sign, but that's going to be a broker by broker decision. So just talk to your broker and understand how they want it. And again, I really hope these brokers put the policy in writing so that it's clear. We want to make sure there's clear authority for who can sign what. Yes, Kathy. You have a question? Okay. Okay. Okay, let's talk about the listing agreement. Primarily, it's now list, market, sell, and procure a buyer is what you're going to be doing, as opposed to just sell. And we're going to zoom in on these. I just want to give you a couple of bullets. There will be disclosures about negotiation of compensation. The buyer broker compensation must be stated and approved by the seller. Let's not forget approved by the seller, so they're going to know. Concessions may be offered as well. The broker notice is more strict. And again, the cooperating broker is now buyer's broker. So let's talk about the listing agreement. Yoli, you have a question. If sharing compensation information between buyer and agent and seller agent, we are requiring listing agent to put the writing how much the seller is offering. Yes, that's what I just said. And should I, who's representing the seller, ask the buyer's agent to present the buyer's broker? I would not ask for the buyer broker agreement. Just negotiate the compensation. I would not start getting in fights with other realtors about you owe me a form. Negotiate it, sign the broker to broker a compensation agreement, and move to closing. Okay.
So see, I have a
Yes,
question.
Christina.
So when you are working with the listing couple and they've
Okay.
agreed on to pay X on their listing agreement.
Okay.
Back in the day, right, like a week ago, sometimes they said that you can go ahead if you can negotiate and save me some money on paying that buyer broker, go ahead and do so, right? I've been involved in stuff like that. Right. So now we basically can't do that. Is that correct? Because they have agreed on X.
Well, that's a great question. Let me get through the listing agreement a little bit, and we're going to talk about that based on the language of the listing agreement. And I'll preview it, foreshadow that I'm not 100% in agreement with the way it's being done, but this is the form that's being offered. So let's talk about that. Give me a minute.
Sure.
Okay. So we're clarifying what the listing agent is doing. You're going to list, market, sell, and procure a buyer. And there are some minor edits throughout the form. So I'm not showing you all the minor edits to clarify that it's a potential sales contract, and an effective date is not a capitalized term in the agreement. It shouldn't be. I don't know why it was. So just note that we see the few of the red lines that it's some of these changes are minor, and we're not going to go through all the little nits. All right, so the termination date, this is a very important change. It used to be 9 months, now it's a year if you leave it blank. So your listing agreement goes for a full year if you don't fill in the time for commencement and termination, right? So make sure you note that your listing agreements are now for a year if you leave it blank. So the broker is obligated to try and sell and procure a buyer. This is a change. But again, these are your duties. Make sure you know what you're going to be doing, because that's what you're selling to the customer, to the buyer. Okay, compensation. This is the new compensation fields, and I didn't do the red line on this one because it's too messy. But again, compensation paid to the real estate broker and any broker commissions are not set by law and are fully negotiable. Seller shall pay total compensation to the broker if a buyer who is ready, willing, and able to purchase the property is procured. So it says here, going back to Christina's question and the other questions about who pays what, seller shall pay total compensation to the broker if the buyer is procured. What is the total compensation? It's stated here as a percentage, and check this box, and here as a dollar amount, or you charge a fee, or you can write in other. But this is the total compensation. I'm going to circle this in blue, because this is the field you're going to use a lot. Right there. And then this is going to be your transaction fee right there. Monica, you have a question? Okay. Then, now, this is really important. Broker has explained to seller. So this is you explaining to the seller that if the seller offers to compensate a buyer's broker has procured the buyer, such broker compensation will be deducted from the compensation. That's this number up here, with broker retaining the balance of the compensation to be paid by seller set forth herein. So that should answer your question, Christina, and everybody else who's saying, how much does the seller owe? The seller always owes the X top line number. They always owe what you put in this blank right here as a percentage, or this blank right here as a dollar fee.
Sam,
Yes.
so it says, I'm trying to look, it's a little small for me, but you said the top number, let's say it's 3 bananas,
Let's
okay?
say X, it's X.
All right.
Even
I like
bananas will get us in
bananas.
trouble with antitrust.
Oh my goodness, okay. So you're saying that it will be deducted from the compensation. This is not talking about the split yet.
This is no, this is the split. This is the
So-
split. And the split amount goes down here. If you can see my
Okay.
mouse where I'm circling
I
right now.
jumped. Okay, I jumped. Okay, great. You're gonna get to it. Thank you.
Yep. Yep. So this is the split amount. Yep. So the buyer's agent and broker, even if compensated by broker or seller, may represent the interest of the buyer. That's very important. You get both sides of the deal. You're allowed to do that still. There was a question about that from a lot of people. You can still double side deals and get the full compensation up here. Of course, we give the warning again. Seller elects the following, and then you pick. Elects to permit, does not elect to permit the broker to offer compensation. If they're going to offer compensation, then this is the amount that goes right here for X, or a fee goes here or other. Everybody see that? You understand? Any questions about that? I'm sure you have questions about this before I move on.
Sam, real quick, I do have a question. Why
Yes,
would there
Debbie.
be any question at all, or why would any listing agent ever not disclose right from the get-go that there is a seller compensation being offered to the buyer's agent? Why would there be any suggestion of withholding that at all from the very?
I wouldn't do it. And as a matter of fact, that's what I want to point out. Thank you for bringing it up. Broker shall pay to any such buyer's broker. So the seller is directing you with a shall pay, not a may pay or a could pay or a would pay or might pay, shall pay. So I would just tell the buyer or the buyer's agent, you bring me a buyer, seller's authorized me to offer X as a co-broke. I don't know why you would fight about it, but I just foresee people fighting about it because they're trying to.
Why? Yeah, but why? I mean, I don't understand why there would be
Well, the number one thing that comes to my mind is in a low ball offer situation, the seller may say, you know, I'll take the lower amount, but you listing agent or you buyer's agent, you're going to take a hit because my net goes down.
Okay, that's a whole nother discussion.
Right. It's a huge conversation. Yes.
Yeah, but so far as if we have a listing and we as a listing agent have already negotiated this with the seller, then that should be presented from the very get-go, no hesitation by any buyer's agent.
And I can't say strongly enough that I agree with you. I just am very concerned it's not going to happen.
Why would it not happen? I don't understand.
Sorry.
Why it not happen.
Because people want to get the best deal possible.
But it's already contracted and agreed to on this listing agreement.
I agree with you, but
Yeah.
I'm very nervous for what's going to happen. Let me put it that way. Darlene, you have another question?
Well, I just want to say that when this came up, if you've already got this in writing and your seller is on board and is already agreed, then where's the problem with putting that broker to broker agreement in writing on the breakfast bar? So when they come in to see the
No, I
home,
agree, that's fine to do.
you know,
If your
and
seller
everybody
says to do
kind
it,
of feels like we're going to work together to make this deal happen for both parties. Like, let's not make this such a confrontational
I
event.
hope this happens. You don't understand.
That's what I'd like to see. It depends on your seller, but
Yeah.
it all starts with the listing agreement, in my opinion.
Yep. No,
I don't
that's
think
correct.
so. I don't think so because
All right, Cassidy or Marianne, go ahead.
I don't think so because, as you told me before, it is negotiable until both agree. So this compensation on the table at the listing home is very nice as long as it is full price, but otherwise this will just be useless because everything is again negotiable afterwards.
Right. So
Sam,
let's, I think the as-is contract is particularly dangerous because the buyer can simply walk if they don't get the deal they want. It's as is, it's a free look during the inspection period. So that's another twist on this. Christina, do you have a question for Cassidy?
Sam, Christina.
Yes, Christina.
In a couple of the courses, right, and explanations, we were told quite clearly, because typically, again, back in time, this was always negotiable, that to leave that second part, D, as a 0 at this time, until you receive the offers and until all the negotiating is done.
That's a strategy that I've heard some realtors say. I think that's going to frustrate a lot of buyers and buyers agents, but I've heard that strategy said as well. You would check this box down here and say does not elect to permit an offer, and then that forecloses, the seller, the listing agent from making offers of compensation. And so buyers, agents who are not supposed to filter based on compensation, but who have a natural inclination to do so, it may reduce the pool of potential buyers. And by the way, the cure for that, coming up on my next slide, is to offer a concession separate from compensation, so that if the buyer needs help with closing costs, because they may be paying an agent, they are going to have closing costs and prepaid items if they're getting a loan. Let's just go to the next slide. So you can do the concessions separate from the compensation. So you can, and again, it's going to be a manipulation and a back and forth all the time. Okay, Dawn is saying we need to figure out exactly where the overage goes. The seller's agent. It goes to the seller's agent, Dawn. That was in the agreement. That's in the agreement. I just pointed that out. That's right here, with the broker retaining the balance.
I was just going to go back to her question from earlier too, because it is the totals in the agreement, but the buyer broker compensation that's being shared is also in the listing agreement.
It is. It must be approved by the seller.
Right. So, but the buyer broker agreement apparently supersedes everything.
On the
And if
buyer
they have
side,
a lesser amount.
On the buyer's side, the buyer's agent can only get what is in the buyer broker agreement. So if the buyer broker agreement says X, and this agreement, the listing agreement, says something more than X, you don't get the more. The difference goes to the listing agent in this agreement.
Unless it's amended, correct?
Unless you do amendments. That's why the amendments are going to be so important. Because getting all this lined up for closing is really what you want to do, so that everybody gets paid.
Yeah, but does it say somewhere there that any overage goes back to the listing agent?
Yeah, that's the part that I just underlined. Broker retaining the balance of the compensation to be paid by seller is set forth herein.
Oh, I'm sorry.
It's in 2A. It's the last part of 2A.
The problem with amending after that fact as the buying agent is if the seller then knows that you were contracted for X and that they were going to give more, and that the listing, it goes back to the listing, then you really can't amend unless they're agreeing to it ahead of time. Because they'd say
the seller agreed to the top line number at the beginning. They agreed to their X at the beginning.
Right, but it talks about overages staying with the listing. So if the buyer broker, so you'd have to know that as a buying agent, oh, hey, they're offering that. I better renegotiate my contract with my buyer to make sure I get the overages, or they're gonna stay there.
So you cut out there, Christina. So they're gonna
Okay.
what?
So the buying agent, let's say they have their contract, their BBA. Then they find out that the listing agent and seller were offering more than what their compensation was going to be.
Oh, so the listing, the buyer's negotiated X, and then the listing agent's offering more than X. Okay.
Correct. So then at that point, as a buying agent, the only way to reap those extra funds would be to amend your BBA. But
Correct.
a lot of time, I mean, at that point, you've already had this discussion because you have found out how
And
much.
you're going to go back to your buyer and tell them that the seller is offering more than X. You want the more, and the smart buyer is going to ask for a piece of it.
Right, but wouldn't the seller at that point, this is just a hypothetical, wouldn't the seller at that point say, well, wait a minute, we already knew that they were contracted for X, so that means I'm going to be able to keep Z.
No.
Oh,
So
okay.
They've already agreed. They've agreed. You assume the listing agreement is signed first because it's the listing that you're going to a listing. So they've already agreed to pay their X, their top line number. They've already agreed to this amount up here.
Okay. All right. I'm just was concerned with this part saying retaining the balance of the compensation to be paid by the seller. That part in A.
Yep.
That's where
That's
I'm
what we're
getting
talking about. That's what we're talking about. The seller agreed to this. That's what you get. Okay. All right.
Hey,
Let's
Sam,
talk
one
about
more.
concession. Yep. Go ahead.
What, can you go back one slide again, please?
Sorry.
Sorry. So let's say they choose 2D part 2, which is does not elect to permit broker to offer a portion of the compensation to the procuring buyer's broker. So that's on the listing agreement. But when we actually start getting offers somewhere on the sales contract in other terms, it's going to say, no, we want X amount to be paid from the seller to help compensate the buyer broker. Can you make it part of a contract?
You would amend. And you amend, and we have an amend list. Let me get to the listing amendment. That'll answer some of y'all's questions too.
Okay.
Let me get through the rest of. Let me get through this then, because the amendment has a lot of information on it too. The new amendment.
Okay.
All right. So your seller concessions does not elect to offer concessions to a buyer, or does elect to offer concessions to a buyer, does or does not. And then you put the amount or the percent, the percent of the purchase price towards the closing costs and prepaids, which amount may be used towards the payment of compensation to a buyer's broker. Because again, money is fungible. So be careful there. Note that concessions may go towards buyer broker compensation because the money is fungible to the buyer. Now, last thing on this slide, very important. We now have a requirement that the seller provide accurate and current association information. And I know that you all are worried about compensation, but as a closing agent, it is always frustrating to have the seller not know the association information. Now they're going to be required to provide it. Okay, we have a couple more questions. Cheryl, at what point does the listing agent let the buyer's agent know how much the compensation that the seller is paying? So that is what we're talking about, Cheryl. I would do it up front. The listing agreement says shall. You discuss the scenarios with the seller. I would just tell the buyer's agent the co-broke is X. If you bring me a ready, willing, and able buyer, I'll be a happy person. The seller will be happy. But I foresee the unfortunate situation where the seller's like, don't disclose that immediately. Let's get the best deal possible. So I don't know. Okay. Seller has the obligation to pay. They are going to, the seller agrees to verify the compensation for both brokers. That's going to be the form that we put out with the with the settlement statement, and they agree to pay seller concessions to the buyer if elected. So, if applicable, it says. And then the seller now agrees at their own expense to provide all current property management and association information, including the application forms. I think that's going to be very important. It should have been in there the whole time, and now it is. Then you've got your notice. So again, notices required to be given under the listing agreement shall be in writing, and notice to the associate is not notice to the broker. Yeah, Sharon, I love the association piece too. So notice to the sales associate is not notice to the broker. Be very mindful of that. The broker has to be notified of breaches of the listing agreement. Hence the new signature block for the listing agreement. Again, seller sign, seller sign, seller sign, seller's printed name, seller's information for notice. Please don't skip this, I beg you. Also, broker information for notice. Please don't skip this, I beg you. Please make sure that you fill in this information and check with your broker for your authority to sign, for the sales associate to sign. Okay, so I said we're going to talk about the amendment to the listing agreement, changing compensation or adding concessions. So this is for current listing agreements, not the new ones after the August 17th deadline, or if you've signed the ones, and they very clearly say in red, this is for NABOR forms with a copyright date on or before October of 2022. So if you've got a current, a listing, I keep saying current, if you've got a listing agreement that was signed some time ago, then you'll want this amendment to the listing agreement for compensation and concessions. If you've got the new listing agreement that I've just finished going through, you don't need this amendment. Everybody understand? You don't need this amendment on the new listing agreement. This amendment is for old listing agreements. And this is what it looks like. It mirrors the new listing agreement. So it takes your old listing agreement and makes it like the new listing agreement. And again, the buyer elects to permit broker comp or does not elect to permit the comp. So this is for amending the compensation. Also, this is the most important part of this amendment for your old listing agreements. Offers of compensation to buyer's broker and other buyer representatives shall no longer be displayed in the MLS. In our current NABOR listing agreements, it says that the compensation, the co-broke shall be displayed in the MLS. That's not going to happen anymore as of August 1st. So you need at least a blank amendment with this language in it signed to clarify that. And Florida Realtors and National Association of Realtors have a one-sentence disclosure. NABOR chose to do an amendment form. And then you're adding concessions if you'd like. You can elect to offer or not to offer concessions. And then the seller shall provide verification of and pay buyer broker compensation and pay any seller concessions to buyer if elected. Questions about the amendment? Okay. This next form is the broker compensation disclosure. I personally don't see the need for this form. I don't understand why it is promulgated when you've got the amendment. However, it is. I'm going to zoom in on it so you can see the meat. And I will tell you that I don't like this form because if you read the last paragraph, if seller's current listing contract with broker authorizes broker to make an offer of compensation to buyer's broker that procures a buyer and or requires the display of any such offer of compensation to a buyer's broker that procures a buyer in the MLS, so on and so forth, then this disclosure shall serve as an amendment to the listing contract. Just use the amendment. I would not use this form. It is being offered by NABOR, so I am telling you about it today, but I would not spend time giving a disclosure when you need to either amend your listing agreement or leave it alone. And I will tell you that there is a big dispute among the lawyers that are involved in this as to whether you need either the amendment or this form. So I'm of the mind and the group that says you need at least the sentence that says you're not offering compensation in the MLS. Some people think you don't even need that. And some people think you need much more. And that's why this compensation disclosure form was created. Okay. All right. NABOR had a few additional changes. They updated the vacant land listing agreement to match the residential listing. And they updated the new construction broker services disclosure to add the compensation is not set by law disclosure. And then the sales contract concession addendum is added in the broker compensation disclosure that we just talked about. So let's talk about the sales contract addendum for concessions. This is an addendum, so this goes with your offer. Zooming in. This is the bulk of it, or all of it. You have your seller and your buyer names. You have your real property, your address, and then you check the box for the credit in the amount of X for the purchase price towards closing costs and prepaids, or credit in the amount of X of the purchase price towards buyer broker compensation. You check your boxes, put your amounts in, you have a blank for other, and then the parties sign. Buyer and seller sign. And this is an amendment to the sales contract.
Okay, can I interrupt, Sam?
Yes, Darlene.
Sorry. So you have a seller who said, I'm not going to offer any compensation. But I'm working with a buyer. When we send over our sales contract, I will include this addendum, and I will choose the second one that says we would like the seller, to credit the buyer that can be used towards the buyer broker. So essentially
the listing agreement will have to be amended and the seller will have to approve.
Right. But at least this is in the sales contract. It's very visible what the buyer's looking for. And then the seller can decide if it's a really good offer.
Right.
Maybe all right. Thanks.
That's exactly correct. Christina?
So you'd actually have to go back and amend the listing when they're signing an addendum.
If the listing agreement says I elect not to offer compensation, but then the buyer wants the co-broke in the credit because they've already, for example, signed a buyer broker agreement, but the settlement agreement states that it must be that the comp must be in writing and approved by the seller.
Correct, but would this not addendum with the correct date signed by the seller then negate what was in the listing agreement?
No, this is an agreement, you'll note, as I pointed out, between the buyer and the seller. You have an agreement with the seller as the listing broker that's not involved here. You need to amend your agreement with the broker, and the seller need to come into alignment.
So that could be a cross out with an initial.
Yes, cross out with an initial.
Sam, as a follow-up to that question, though, they may just be changing it for that deal. So then am I to assume if that deal falls apart and they want to revert back because they agreed to it because of that offer, then you have to amend it again?
Well, I would probably do a much more concise amendment. I would say something like, if Bob the buyer buys this property at this price, I agree to offer broker compensation in the amount of and credit it, pursuant to the contract, because it's done afterwards. I would be a little bit more comprehensive if the seller was going to go down that road. I mean, yeah. So maybe Christina was saying you need to just cross out an initial. Maybe you need to do a much more concise amendment to the listing agreement. But the settlement agreement clearly says, I'm trying the paragraph. Where's the seller one? Yeah. Require realtors and realtor MLS participants acting for sellers to conspicuously disclose to sellers and obtain seller approval for any payment or offer of payment that the listing broker or seller will make to another broker, agent, or other representative for acting for buyers, and such disclosure must be in writing, provided in advance of any payment.
Why would they not on this addendum then place other signature areas?
Because this is between the buyer and the seller. This is a sales contract addendum. This is going to go with
What
the
Renee
offer.
is saying, what Renee said makes a lot of sense, because we could be going back and forth, and once you amend the listing agreement with an
Right.
amendment or a cross out, it's amended. Then you have to go back and change it again.
Well, I would do a more concise, I have to think this through a little bit on the fly here, but I would probably do what Renee was suggesting, which is a much more concise amendment to the listing agreement that says, if this buyer closes, I agree to pay co-broke of X. And
Oh,
then
make it
match
buyer
the addendum.
Make
Oh,
it
I
buyer.
would be, as I sit here thinking about it now, having been asked that question for the first time now, I would be specific.
With the buyer specific, the name.
I would be, yeah, of course, the property, of course, is the property, because that's what the seller is selling. But I might even be specific to this buyer, yes.
So once if
That's a good idea.
you're making it buyer specific, like Renee is saying, then let's say that deal falls through, we
Sure,
don't.
you don't have to go back and amend again.
Okay, that's excellent.
Yeah.
Thank you.
It just, it repeatedly doesn't make sense. If the listing agreement is between the broker and the seller, and this addendum is between buyer and seller, I don't see how that affects the listing agreement at all.
Well, let's think about this, Jennifer.
Yeah, because.
So the
this
seller is
whole
offering, the
lawsuit
seller and the listing agent have agreed to X. And
with no
the
buyer
seller is
broker
selected not to
compensation.
offer broker compensation.
Right.
You have a listing, you put it on the MLS, you have your website, you have all this stuff, and it says no co-broke offered. Or you say nothing about the co-broke, and you receive an offer with this addendum to sales contract for concessions attached, and this box is checked, and they want X to go of the purchase price to go towards buyer broker compensation. And your listing agreement says no broker compensation. Based on this language I just read in the settlement agreement, that you have to agree in writing and obtain seller approval in advance and specify the amount or rate of the payment in the listing agreement, I think that you would need to amend the listing agreement to match. Now, will that happen? I hope so. But
Sam, couldn't this agreement be in excess of what's committed in the listing agreement?
you could have a
Meaning,
situation where it's in excess. That's right. And I would say that if it comes back in excess, if the listing does offer the buyer broker compensation, the co-broke, then I could see where you would make a counter offer of this addendum to bring it down to match the co-broke, the offered compensation that the seller's already agreed to.
no, I mean, does this have to be treated as a co-broke? So the listing agreement stays pure. It says, look, there is no co-broke, but this was negotiated and it's not called a co-broke. It's just a concession that can be credited to the buyer's agent at closing, but it still doesn't affect the co-broke, because a co-broke means I'm sharing some of mine. I don't know.
I would like, I see where the confusion is coming in, and I have to think this through in greater detail as well. So you should expect a title tips email on this at some point in the future once I've had a chance to talk to more agents about this. But I'm of the mind that the forms are going to have to match if you get audited by the MLS. Because also what I didn't mention at the beginning is the MLS has audit rights. They can ask to see these agreements. And I would like to not have anybody get fined by MLS. And I don't know how that's going to how that's going to go down.
With the addendum, Sam, since you're on some of the committees to write them, though, couldn't it be, again, a simple addition to this addendum saying this and signed, this supersedes X in listing agreement?
I will certainly ask that question of the committee. I think that's a good question. I'm sitting here staring at the settlement agreement terms, and I'm reading them to you. And
It just seems like an addendum is an addendum, an amendment is an amendment, and to have to go back and redo other forms that were originally done, that's not the purpose of an actual, once you add.
I think Deborah's got the best suggestion. Can the initial agreement be changed to may offer concessions to avoid future amendments? I think that may be a solution, Deborah.
Super fun.
Sorry, someone was unmuted. All right. Other questions about this before I move on to the last section? Okay, so I do want to share, take 2 minutes, 3 minutes here at the end, and just share some tips and tricks to get through this. I've been doing this for over 16 years as a real estate attorney. I've been an attorney for over 20 years and I've done almost 20,000 transactions. So let me just kind of give you some thoughts. Number one, stay educated. I would really think it's important the realtors be the experts on real estate in their area and be prepared to give advice at all times. I think the number one complaint about lawyers and the number one complaint about realtors is the same thing. They don't answer their phones. Please answer your phone. It's going to be a lot of fast moving negotiations, I think, especially until we get a rhythm as professionals together. So I love this quote. This was from 2023 from Inman. And basically they're saying that you guys do so much work, but you don't get paid up front. And now maybe with buyer agency agreements, you will. The other thing I'll say is you got to learn to do research, again, to make yourself knowledgeable. I would learn the rules and regs of my communities, you know, all the stuff that you have to deal with. I would know somebody in the building department so that you have a contact for questions about permitting. This is the number one problem in Florida right now, insurance. Gosh, it's such a pain to get a deal done because of insurance and then to throw compensation issues on top of that. So I'd have a good insurance agent and be the source of the source. Be the source of the source. Have a good stable of people helping you. Lastly, or not lastly, but build relationships that last. You got to have a good reputation for getting the deal done. And I think if you are someone who brings the deal and not the problem, then you'll get more information about compensation up front. I really think that's going to be a big deal. And then the last thing I'll say before I take any other questions is you got to know your value. And I love this quote from Inman. Buyer's representation is quite comprehensive, involves ongoing communication, being extremely proactive, problem solving, troubleshooting, double and triple checking, following up, and assuming nothing is as it has been purported to be. Buyers don't know what they don't know, and those who don't have representation often find themselves in a problem or situation that can have serious financial implications. This is what you guys do. You save the buyers money. You bring expertise. And then NAR put this publication out to talk about what you're worth. I take a gander, that's a couple of pages. All right, questions? Anybody? I can see Darlene.
Sam, just out of curiosity, do you have any sense of how many deals your office closes without a realtor involved? That somebody who is just a real estate agent and not a member of NAR?
No idea. If I was guessing, I would say none. You mean like Thompson brokers or just sales associates who are not realtors?
Yeah, because obviously
I'd be shocked if I saw any right now, but I don't have a real sense.
You know, because certainly in other parts of the country that is not uncommon. And so I just kind of wonder if a savvy buyer is going to, say, well, I'll just seek out somebody, a regular real estate agent and not a realtor, and not have to go
Well,
through any of this.
there was a post on Instagram, and Instagram is what it is. Let's take it with a grain of salt. But they said that Colorado has said that buyer broker agreements are not required, the settlement agreement says that state law controls, and that is a point that was made in a post that if it's an NAR member who is considered a realtor and a sales associate or Thompson broker who is not a realtor but who is licensed to sell real estate, is there now a competitive disadvantage to being a realtor?
Yeah.
And that's going to be a very tough and interesting, conversation as we go forward. You're right. I can't answer that right now because I can't foresee the future here.
Yeah, there's some large markets, New York City being one of them,
Yeah.
that don't utilize an MLS.
Don't even have, that's right. And I've been
Right.
told that New York City does not even have an MLS. Yes.
Yeah, hi Sam.
Hi, Mona.
Hi. Are you planning on going through the same thing with the forms for FARBAR?
On August 15th, I will be doing it.
All right. Thank you.
August 15th. I don't know the exact time. I should know the time, but I will get that out to everybody.
Very good. Thank you.
Sam, hey, it's Dawn Johnson. Can you hear me?
Yes, Dawn.
If you have
Hello,
an
this is
FHA,
Renee.
Hold on. Go ahead, Dawn.
if you have an FHA buyer and their closing costs equal 8%, the lender only allows up to 6% for seller concessions. For buyer broker, then do a referral fee from broker to broker.
No, the broker compensation is not controlled by FHA. It's if the listing broker is paying the buyer's broker a compensation, then that they have said that will not be a part of the concessions. So if you've got I believe the concessions under Fannie Mae and Freddie Mac range from 2 to 9% depending on the loan product. I saw that on Fannie Mae's website a couple of days ago. So, and I'm not sure if that's a change. I thought it was 6% was the max too, but the website clearly says 2 to 9. So, I'm not sure how
Let's just say it's 6.
so if the product allows for a 6% concession and the seller is offering that concession, you're asking me what happens to the broker compensation?
Yes, I thought we would do referral broker to broker.
Well, you don't need a referral. You need the broker to broker compensation agreement that I went over earlier. It wouldn't be a referral. Referral is where the referral agreement under NABOR is where you offer to pay somebody else once they
See,
give
Lois?
you. You hear me, Don?
Yeah, I
Yeah.
heard you.
So I wouldn't use the referral agreement. I would use the broker compensation agreement that we went over a few minutes ago.
Okay.
Other questions? Sharon, yes, I'm going to send the recording out. I will get the recording out as quickly as possible. Darlene,
Sam, oh, sorry.
yes, Vivian.
You mentioned to include the addendum to sales contract concessions with your offer.
Yep.
Is that instead of getting a broker to broker agreement, or
No. Remember, the concession addendum is an addendum to the sales contract between the buyer and the seller. This is where the seller is agreeing to pay concessions or portions of the broker compensation to the buyer to cover their costs. Yeah, let me go back to that form. You can see it again.
not A, but B, where it says towards
Credit in the amount of blank of the purchase price towards buyer's broker compensation. But again, it's between the buyer and the seller. And I'm sitting here thinking about this. If the seller signs this, they clearly have been disclosed and know about compensation. So maybe whoever it was earlier Jennifer, or I don't remember what it was, is correct. Christina, maybe this is enough. As I sit here thinking about it, I mean, it says it says in the settlement agreement that it has to be approved in advance and done in writing and specify the amount of payment. And they're talking about the listing contract. I can show you this language. I can make it clear.
Oh, I can't read that.
Yeah, it's gonna be very. You got it. It's paragraph 8 of paragraph 50. It's section 8 of paragraph 58 of the settlement. If you pull up the revised, the corrected settlement agreement, it's on page 29.
Is it in advance? What's it in advance of? In advance of finally
the payment
agreeing?
in advance of the payment or agreement to pay another broker. It says provided in advance of any payment or agreement to pay to another broker acting for buyer. I mean,
So would this count, this addendum then, on a sales contract?
I wish I could say definitively and give you clear advice. I cannot, because this is unclear. I'm going to bring this up with the Legal Resources Committee and see what they think, and it'll be in a title tips email probably in a couple weeks.
And if it was signed by, if it's signed by brokers or something, would that help? Or I don't know.
I think Christina mentioned that, and this is between the parties, and there's a strong resistance by the lawyers and many realtors on and off of the Legal Resources Committee to keep the agents out of the sales contract. And I think that's probably a smart thing, because the sales contract is complicated enough between the buyer and the seller. And if the agents are now signing the sales contract as like a third party beneficiary,
yeah, that's not good.
At the Florida Joint Committee for the FAR forms, I brought their attention. There is actually a case that very clearly says that realtors are not part of the sales contract and are not third party beneficiaries to the sales contract, which leads me to think even further that the listing agreement will have to be amended. And I really like the suggestion that was made earlier by
May.
Well, May is one thing, but I think that it needs to be buyer specific if you amend the listing agreement.
Sam, can you scroll up? What's the name of this form exactly?
It's an addendum to the sales contract, and you're sending it over with a sales contract.
Addendum. Yes, Jennifer, if you can see Jennifer's comment to everyone in the chat, I agree with that. So again, if I can just say, we should all be working together. We're all going to have to figure this out. And we know each other in terms of our personalities, if not our names. And we know that some people are going to be difficult to deal with, and they're going to want to play games, and there are people who are not going to like this and want to manipulate it. But those people are going to get filtered out, because this is going to be a much tougher market, in my opinion. But I could be wrong. I hope I'm wrong.
Hey, Sam, it's Dawn again regarding the FHA buyer.
Yep.
You know, when the seller lists and initially says, okay, I'll do, a certain percentage for concessions, and he's kind of thinking, co-broke or whatever, to recompensate, buyer's agent. But I guess I see there's two sections. There's for the broker, and then there's also for concessions, but I just don't think that they're going to sign up for enough of what's required really for an FHA. But I guess we can do that in amendments at the time, because a lot of these FHA buyers need they're going to need the full 6. They're not going to do 6 on paperwork up front, I don't think, because they don't know what kind of offer they're going to get.
You mean concessions for prepaids and closing costs type of thing?
Yeah.
And listen, you're going to have new home buyers, FHA buyers, young couple, like I said, all these people that we know, that we work with, that just don't have a huge amount of money, but for whatever reason are buying a home because they're smart, because their work has changed. They don't want to pay rent. They've saved up the down payment. And that's why, money is fungible. So you're going to get a lot of people that you know, not understanding this, but they want to see their monthly payment and the amount they have to bring to closing. And, you know, if I can toot my own horn for a second, if you call me up, I will get you a settlement statement as best I can with all the details if you have them. And we will help the buyer figure out their budget for the transaction and for owning this home up front, so that you know that you're not wasting. Because I think I don't want you to waste your time as a realtor taking buyers out only to find out that they can't afford the home because they got to pay concession. They're not getting a concession, and they got to pay you, and they got to pay for the closing costs, and they got to pay for the down payment. So
Yeah, I think it's really important
buyer financing is going to be a big deal. And when you get to the insurance, it becomes an even bigger deal.
Yeah, I think it's really important for listing agents in those certain areas or those pockets to really think about that 6% for seller concessions for those buyers.
Yeah,
You
well,
know, straight out the
again,
gate.
you keep saying 6 for concessions, but I read recently that it's between 2 and 9, and it depends on the product. So,
Yeah, I haven't heard of 9 lately. I'm just giving an example.
yeah. Okay, other questions, Christina? You have one?
Totally different subject, Sam. So I know that it has to be clear and concise commissions and communications between sellers and buyers. So working with a buyer, right?
Yeah.
Not wanting to leave X on the table.
Right.
Currently been working with them for 6 months. I'll use an ongoing example right now.
Just don't use numbers.
Nope, I won't. Been working except for 6 months, I'll say. So we're narrowing down now, and it should happen before October, November, whatever we find them. There's been on the past listings, you know, A offered and B offered. I don't want to leave the money on the table, so I'm going with B, saying that B is more than A when I'm doing my BBA, which is tough because I'm going to be asking my sellers, who are my buyers, my buyers, to either value me at that extra little bit amount that maybe the seller might not be offering, and I prove my worth, that I'm worth it. Okay, great. I get them to agree in a perfect world. If I don't, and they say, well, no, we're not happy with that, we want you to go with A to begin with, it will be more difficult for me. I believe it's going to be more difficult for myself to go back to them and get them to come up to
absolutely
B compensation. So my question would be, if I have it with the B you know, instead of A, I put B on my BBA. And then am I allowed, because that's clear and concise, am I allowed then to do an amendment with my buyers ahead of time saying, I will agree to lower my compensation according to what may be
you
offered?
absolutely cannot do that. You have to be clear and concise and upfront.
So it's tough because
It
it's
is
so
tough.
much
They
better to
don't
go
want,
up than to go
you gotta
down.
remember, Christina, the Department of Justice and the plaintiffs don't want any money coming from the listing side going to the buying side. So the back and forth, the negotiation and the subsequent amending of agreements is the workaround. You cannot have a formula that is not clearly ascertainable as to the amount prior to dealing with the seller in the buyer broker agreement.
So
in
basically,
your example, if you value yourself at B, then you are entitled to B. If you want to lower B later because the listing side is paying less than B, that's fine. You can do that. If the listing side is paying more than B, you have to go back to your buyer. Hey, buyer, we talked about B. The seller is offering C, which is more. I would like the C. Please sign here.
Yeah. So that's a conversation I don't see going well. I see the opposite.
Of course it's not going to go well.
Okay.
I see the astute buyer saying, sure, we'll go to C, split it with you.
Exactly.
And that's unfortunate, but again, we're dealing with a settlement agreement that is unclear. We're dealing with a settlement agreement that is not comprehensive, in my opinion. Clearly, whoever wrote this does not sell a lot of real estate.
Right. So flip the coin, Sam. Let's go with the other aspect where I'm going to be asking for B ahead of time And then I'm gonna have that conversation. I'm just trying to come across what I'm gonna do in my mind, right? So then I'm gonna say to them, but listen, Mr. and Mrs. Buyer, when we do find out, since I'm asking for B, if they were offering A at that time, verbally, I'm gonna say, at that time, I will amend with you down to
Yeah,
A.
you can certainly have a verbal discussion. Listen, I view that my value is B. I expect to be paid B. If the seller offers more than B, I would like to receive more than B. If the seller offers less than B, I will consider taking less than B. But between you and me in this moment, I'm going to follow the law. And it says, the law says that I have to have an agreement signed with you for B. So you are going to agree to pay me B for me to work with you.
Yeah, and I see this more, so maybe I'm incorrect, but dealing in the luxury market, right? Because there's just this little
A little
tiny.
more sophisticated buyer is there's
Yeah.
gonna be a lot more conversation. Yes.
Yeah, okay. Thank you.
All right, it's noon, it's afternoon. We've been at this for 2 hours. I'll take one more question and then I've got to run and you guys got to go sell some houses.
Okay, very quick two-parter to follow up on Christina's. We can accept less than what's on our BBA without an amendment, is that correct?
Nope, it's
Or
supposed to be amended.
modification?
You are entitled to the amount stated in the BBA. Obviously, if you want to take less, I would just do it in writing so that you're in compliance with the settlement agreement.
Okay, so you still do that. And I've also heard in other similar Zoom meetings that we can have separate BBA with the same buyer for, like, for example, new construction that consistently offers higher compensation amounts. Is that?
I mean,
do
I don't know that
agree
you
with
need to be
that?
separate. I would just simply do an addendum to the current buyer broker, right in the other terms. For new construction purchases, I agree, you agree to pay me Y, which is more than X. The new construction problem that I really see is when they offer Y, which they all advertise what they pay, and then they say plus a bonus if you bring me today, and they don't say what the bonus is, and then you got to go find out the bonus and amend your buyer broker agreement, and then you got to split the bonus.
I was told it had to be on separate forms by multiple people, Sam.
It can be, but I just don't see the purpose in doing it. It can be. It's certainly, I'm agreeing with them. I'm just not saying, why would you do that? Just write in the other terms on this agreement. But guys, I don't want to keep you much longer. If you have individual questions, please contact me. I'm going to send out my slot or my video. I'm keeping the slides this time because I'm going to probably be making some adjustments to them, but I'll have the video posted to YouTube and send out an email. So thank you very much for today. This was very informative for me. I hope you learned something and I will talk to you soon.
Thanks, Sam.
Thank you.